Trust and accountability. We haven't always had it from the tech giants, have we? They already know so much about us. Well, companies have had little incentive to give us straight answers about the personal data that they keep. But now, thanks to European privacy laws, the power balance could shift. You're watching Roundtable with me, David Foster. They are the biggest changes to online privacy rules since the internet was invented. The European Union's putting tough restrictions on how our information is collected and then shared. Change coming in everything from technology to advertising, from medicine to banking.
There's a deadline looming for companies that collect your data online. So it's no accident that banks, online stores and social media sites are clogging your inbox with alerts and emails. They want you to agree to updated privacy policies, so they're compliant with the European Union's new regulations before May the 25th. With sweeping changes to data protection laws, the EU is putting in place the world's most demanding set of rules on how personal information can be collected and used. The General Data Protection Regulation, or GDPR, requires companies to explain simply how personal data will be used and get consent first, notify users quickly of a privacy breach, provide copies of the personal details they have stored, what's called data portability, and delete all personal information if asked.
We want you to understand what data we collect, how it's used, and what you can do to update, manage, download, and delete it.
The fines for companies that don't comply are hefty, 4% of global turnover or 20 million euros, whichever is higher. For Facebook, that would be about $1.6 billion.
This has been an intense year. I can't believe we're only 4 months in.
Scandals like Cambridge Analytica have put a spotlight on data protection like never before, exposing questionable data use and political manipulation.
You as a company welcome regulation?
I think if it's the right regulation, then yes.
You think the Europeans have it right?
I think that they get things right.
Have you ever submitted? That's true.
In effect, Europe becomes the world's online privacy warden. Every company that operates on the continent or has European users is required to follow the stricter standards, and so most international brands are forced to follow suit.
GDPR makes European Union the space and the territory where cheating will be very, very expensive.
Europe's rules are becoming the de facto global standards. But it's a heavy burden for smaller businesses, with some opting to shut their European offices. Demand for free online services as well as privacy are often competing ideas. And when scanning a loyalty card or ordering the latest gadget online, little thought is usually given to what happens to the data freely handed over. But it's the currency that fuels the online world. The hope is that companies who collect it en masse are now forced to care.
At the round table today, we have Rhiannon Evans, young co-founder of Crest Communications, a digital PR agency, so very much of the 21st century. We have Hussein Kanji of Hoxton Ventures, invests in technology and advises on policy, so been very busy on all of this. Kate Bevan's with us, the editor at Which Computing, the independent consumer body, and Ardi Kolah from the Henley Business School, releasing a book called the Gdpr Handbook next month. Thank you all very much indeed. Look, 250 pages. Ardi, I can assure you I won't read it.
Well, unless
but you can tell me about it, so why is it important?
It's very important because, in fact, the regulation, which in fact is law, so many people watching this will think it comes into effect on the 25th of May. That's not actually correct. It's, in fact, the end of the transition period, the 25th of May. Because it touches the deep tissue of all organisations, be that public sector, private sector, voluntary sector and government, the European Commission, who proposed the regulation back in 2012, understood that this was going to be quite a big deal for organisations and companies, and including governments as well. So they gave everyone a 2-year.
But why does it matter
period.
to me?
It matters to you because you've now got stronger rights than you had previously. It also matters to you because you need to hold organisations to account in relation to how they process your personal data. The definition of processing has also changed. It even means just looking at something on a screen. And really,
see, I wonder, and I'm sorry to, I know it's a long answer, but I mean, it's a long story. But when it comes to me having more rights, how am I going to exercise? How am I going to even know I've got those rights? Because it's not something that I think about.
I think that's one of the biggest things. I think a lot of the media focus has been on what companies need to be doing, but there's not been nearly as much airtime given to what consumers can then do with the new rules, whether that's the right to be forgotten, the right to get someone to delete all your data, and there almost needs to be a toolkit that's clearly set out in layman's terms for consumers.
Well, that might well be in Ardi's book. So
well, there is.
Given,
the ICO, the UK's regulator, the Information Commissioner's Office, has slightly belatedly launched its campaign to help people understand their rights in regards to data. I mean, I think it's fair to say it's a bit late to the table, but it is coming, and it should be quite helpful when it's there.
I'm almost positive we're going to see a round of ambulance chasing in this market. Yeah. Or just like PPI insurance, where you get those unsolicited phone calls. People are going to call you up and say, these are your rights, and can we work on your behalf? Yeah. And someone's going to make a lot of money.
Give me an example of that, then.
I think someone's going to call you up and say, do you know you have this? Do you want to sign up for it? And then they'll go be the agent of record to go.
And would I ever get any money, or would I just sort of, would they get the money and somebody else? I'd get wiped off the register.
I'd be surprised if you get the money.
There's no real benefit for me.
But I think there's going to be a ton of nuisance things against companies, right? If you want to take down a company tomorrow, you just fill them with these kinds of requests, with SAR requests, et cetera. You probably know the legislation.
What's an SAR request?
What does it stand for? Subject.
Well, yeah, but let's just take a step back a little bit. For starters, the things we've just been talking about and what we just see in the package about the right to be forgotten, for example, the right of erasure, as it's called in the regulation, that's not an absolute right. There are limited circumstances where that could be exercised. So we shouldn't run away with the idea that we can just get everyone to kind of scrub our data off the internet if we fancied. The actual driving force behind the regulation is about the mitigation of risk. In other words, risk to you and me and anyone processing our personal data. So the ambulance chasing thing, which you were referring to, is an interesting point, but really they could act on behalf of not just you, but lots of other...
Class action type of things, yeah.
We do group action in Europe, not class action. But I mean, yeah, we could act on that behalf. There is a mechanism for that to happen within the GDPR, but those organisations have to be voluntary sector organisations, which is quite interesting.
See, it's all going a little bit over... It's all going a little bit over my head, I have to say.
Right now, I tell you.
Yeah. Sorry to say that, but it's all going a little bit over my head at the moment. We've got acronyms, we've got abbreviations, we've got things that are going to happen like ambulance chases. In other words, lawyers are going to start trying to make money out of this, bring companies down. Why? What's the real issue here?
The real issue is, as we've just said, it's about mitigating risk. Any data protection is a risk management exercise. It's about knowing what data you hold on people, how you process it, who has access to it, what the risks to you are, what your threat model is. Now, that sounds really kind of nerdy as well, but this is actually something companies should have been doing all along, which is putting how they manage data right at the heart of what they do. It's not an add-on to be done by the IT department. It's something that should be right at the heart of the board.
Do I have to say to them, yes, you can do this now, whereas before they were able to do it without?
Not necessarily.
Is it as simple as that?
No.
It's a grey area, and I think
that's part of it.
It is part of it, and I'm sure you've been receiving lots of emails that saying, please opt into our mailing list, half of which you don't even remember signing up to in the first place.
No, you're quite right. But I mean, it's just, if you like that pair of socks, you might click yes.
Well, that's exactly the point. There's been, and I think from a communications perspective, one of the main issues is the definition of marketing. And a lot of, within the regulations, it's being translated as sales. And if I don't want to be sold to, obviously you shouldn't be emailing me. But some marketing is communicating, whether that's communicating with a membership, with existing customers, with people that have actively signed up to hear about your news. And that's the space where a lot of particularly small businesses are panicking, because they're like, can we even talk to our customers anymore?
There is a confusion here. They don't have to send out these, what I call zombie emails to people if they've got an existing relationship with them. And that's
so if I bought a pair of shoes, they don't have to ask me whether I want to buy them.
because you're actually looking at that situation under a completely different regulation called the Privacy and Electronic Communications Regulation, which allows you to continue to do that. It's also very clear under the regulation that there are 6 grounds for processing personal data. Consent, which everyone's going on about and banging on about, it's only one of 6 grounds. There are other grounds that one could use. So it's not fair to simply say the whole thing has to be through the lens of consent.
We will go into the details about how difficult this can be to put into practice for companies out there and how expensive it can be. But first, let me ask you this. You talk about marketing, but really are we talking about this in headline terms because it's about stealing data to use like Cambridge Analytica.
But remember that Cambridge Analytica was...
used in elections and so on, and using it for nefarious ends, if you want.
What happened with Cambridge Analytica happened under a previous API, i.e. the way it connected with Facebook, that Facebook has since shut down. When Cambridge Analytica was working and using the data given to it by Kogan's company, that was a time when you could, as a Facebook user, inadvertently give access to your friend's data as well. You can't do that now. The ethical framework is already better than it was in the days in Cambridge Analytica.
But is this why it's come about, though?
Yes, it's partly.
Yeah, but however, although saying that, and of course things have changed, you do have a lot of class actions in the United States, including the state of California, where the charge against Facebook, of course Cambridge Analytica has gone into liquidation here, but they still have lots of businesses in the US. The charge against them is surveillance capitalism. And that means actually not just simply taking someone's data, but profiling them, adding other bits of data to it, and then selling it for a commercial advantage. And I think that's at the root of what the problem is. People didn't know that was happening. And under the GDPR, you may not have to consent to being profiled, but you have the right to object to being profiled, and people didn't know.
I think the general principle is that the regulators have wanted to take the data and give it back to you so that you are the custodian of the data. And the principle, I think, at the high level is that you decide what happens to your information, and there's more power that flows back to you, because otherwise this stuff is amorphous. It stays with other parties, with companies, and it doesn't, you actually have very little control over it. I don't know if this legislation is going to be clunky. And one of my biggest criticisms of legislation like this in the first place is they are usually fairly iterative, right? You have to do a version 1 and you kind of have to do a version 2 to see what you kind of have messed up.
With everything, though.
With everything, but regulators don't think that way, right? Regulators do one kind of blanket fix, and then you get a lot of...
I would have agreed with that premise had it not been for the fact that this is the most scrutinised piece of legislation ever produced by the European Commission, and it's taken 4 years.
But it runs in a vacuum, right? Until the 25th, we don't know how it's going to work in real life.
No, it hasn't, because it's been law since 2016. This is the big mistake people are making. It's been law, and you've meant to have actually gone through a transition period where you're moving towards this new landscape, which is post the 25th of May.
Has anybody got taken out for it? If it's been law for a couple of years?
No, because it hasn't been enforced. It hasn't been enforced. So you have
this is the point you're making, isn't it?
Everyone's going to procrastinate.
Let's tangle those 2 points, though.
Until somebody comes down hard on you, you're not going to know whether you're on the wrong side of the law or not, necessarily.
But I don't want to take up too much airtime on this, but if you haven't changed what you're doing in terms of policies, processes and procedures, if you haven't put into place technical and organisational measures so you can comply, it's deemed to be an aggravating factor should you have a personal data breach post the 25th of May, and that will increase the level of sanction and fine. So the needle will go up, it won't go down.
What's this about if you have to report something if there is a data breach within 72 hours? So you would be who? A company marketing a product?
If you've discovered you've got a breach.
In what sense would you know that you've got a breach? Did somebody come in and stolen personal data that you had on people? Is that the way?
A lot of the time companies don't know they've had a breach. That's a very good point. Sometimes you don't find out until somebody sends you a ransom note, for example, demanding that you pay 100 Bitcoin to stop them putting it up online. So detecting a breach is actually part of the risk mitigation, it's part of the risk management. Okay. What the GDPR requires is that within 22
When you're talking about a breach, you mean a hack?
A hack, but it's not necessarily a hack.
It could be an accidental loss, it could be theft, it could be an employee sending the stuff out to someone.
So somebody's got to keep an eye on whether this is happening. 72 hours, you've got to report it.
Well, once you know there's been a breach, which means there's potential of harm or damage that's going to be occurring as a result of that, then you're under an obligation to report.
I think we're getting to the point where I'm understanding slightly that you have to split this effectively into two areas, don't you? The one that affects those of us as individuals around the table and the ones that affect companies that have to put these regulations into force. You said something to one of our producers, which is all tech companies I work with have had to have a test to see if they're compliant. That's very costly. What I wrote next to that was test, yeah, so what?
Yeah, I mean, that's...
What's the problem with that?
Test. You just have to be able to prove that you're
You've got to do the cover your ass time test, right?
Which
is you have to go hire someone to come in and do the audit and then show the regulator that if things go bad and someone comes and knocks on your door, you've
But that's
done
fair
the
enough,
work.
isn't it? Yeah. Or is it unfair?
It's fair, but a lot of it is just a tax, right? Your systems may already be compliant, but you now have to go pay someone to come in and certify.
No, that's not quite true, because you're only expected to carry out what's called a data protection impact assessment, which is actually a requirement under the GDPR. So if you have a high or very high risk in relation to the processing of personal data, if it's low or medium, you don't have to do a DPIA, as it's called, but you need to record the reasons why you haven't done it.
Let's ask Rhiannon about this one, because now that we've split it into those two camps, and I know I'm making it black and white when it's all shades of grey, but you're dealing with digital companies, right? What are they telling you about this? Are they happy with it, or is it a real problem?
I think both your 2 points are really interesting, because it makes complete logical sense that companies are panicking to a degree. So they're getting people in who profess to know what they're talking about, so that they have the assurance that everything's okay. And at the same time, people who have a more granular knowledge of the legislation know that actually they maybe don't need to do that. So I think from a company's perspective, confusion is, the word of the day. They're not sure what they have to do. And yes, it's been around for a while, but I think particularly small companies who don't have the resource to have had whole teams working on this since 2015 don't really know what to do. There's a lot of misinformation out there. There's a lot of charlatans out there looking to make a quick buck off the back of it. And some of them are being taken for an absolute ride, when in reality, some of them are actually already doing everything properly.
What about this headline? Are Google and Facebook undermining Europe's privacy rules? Gaming the system was the way somebody put it.
That's a really big statement to make. I mean, Google and Facebook are definitely two of the biggest players in the data landscape. Are they gaming it? I think we've all been playing catch up with the technology as time has gone on. We've only been doing this for 20 years, really. This legislation is kind of catching up with where we are now, and Google and Facebook are among those people playing catch up. They have a lot of power because of their size and the amount of data they have.
Well, one of the things I read in this article is that they are transferring certain operations to Facebook Africa or Google Africa, because then it doesn't come under the European regulations.
Out of all the companies in the world, they can probably figure out...
I'll ask you in a second. Yeah, carry on.
Out of all the companies in the world, they can figure out how to work around this stuff. The two most profitable tech companies are probably at the top, right? They can hire all the experts in the world and figure out how to design around this.
To game it?
Yeah.
Yeah.
Look, it's very, very clear. We've moved away from...
Glad you said that.
It is very clear. It is very clear. Read the book. It is very clear. We've moved away from where the processing takes place to a point where the decisions are made in terms of the processing, reasons for doing it, and the means for doing it. So irrespective of where the data processing, personal data processing is taking place, the GDPR applies. So you can hide in many places as you like, but the GDPR has this extraterritorial reach.
Unless you have the power to shut down a company, to prevent it from trading, big fines, what did they say? Stiff financial penalties are going to make not one jot of difference to the biggest companies, as we've seen with the Microsoft antitrust, anti-competitive laws which the European Union slapped on them. So is this going to work?
But it's not just about the fines, though. It's about the reputation of that organisation and whether they've actually done anything to create digital trust, which is the thing which is under attack at the moment. And I think that's a bigger issue.
So why have the fines anyway?
But the interesting thing is, post-Cambridge Analytica, Facebook usage went up, not down.
Yes, I'm saying this idea of trust, I think, is a load of nonsense. If you want to use something, you'll use it, and you'll sort of say, well, that's what they like.
Exactly.
And I think there is, obviously, the aims of the regulation are laudable. Everyone wants to think that their data is being protected. We've seen with TSB, when things go wrong on a tech side, people lose out massively, whether it's fraud or hacking. We don't want our data being shared without our permission. But at the same time, I think the Facebook point's a really interesting one. Our level of caring about these sort of things is actually on an individual consumer level quite low. The Cambridge Analytica thing is a perfect example. People didn't delete Facebook in their drove. Some people did. Some people take a real interest in this, but most people didn't. shouldn't. So it really is on the companies themselves.
Okay, so this comes with the caveat, because it hasn't happened. So I'm saying, I'm just using this as an example. Company A big tech giant on which we post all our social media, is fined £200 million or £2 billion, dollars, whatever. Is that going to make a jot of difference?
I think somebody probably will be made an example of.
So should we watch out for it, or when it happens, should we just think, that's just one of those?
Keep an eye on it.
I don't think it's going to happen in the UK, because the UK's Information Commissioner Elizabeth Denham has explicitly said they're not in the business of slapping enormous fines on people. They very rarely impose, I think they've only imposed once the current maximum, which is £500,000, and you have to have done something really awful to get a fine of that level. So these people
might just as well ignore the new rules?
I think that the reputational point is the interesting one, is the one to think about.
Well, you can argue that one, but as we were saying, Hussein was saying, Facebook's reputation, well, it was pretty low, but it didn't make any difference.
I wouldn't agree with you. I think there's an awful lot of concern amongst consumer groups. A lot of people that I've spoken to are concerned that they didn't know what was happening with their personal data. The other thing which we've missed, I believe, is the fact that actually the GDPR, the General Data Protection Regulation, is actually a human rights piece of legislation.
About which you've written a book. Not that I'm mentioning it again.
It's a human rights piece of legislation, and it refers to rights of individuals, and that's something which we have to hold close to our hearts in Europe, because privacy, data protection is a history we have a long history with, just as much as the Americans have a right to carry arms and see that as an expression of their democracy.
Well, you want to read the second paragraph of that, because it says in a well-organised militia, which everybody leads out. I've got two questions. Tell me what you're going to say, and then I've got two questions, and we're going to try and round this up.
I'm a big believer in the principles, and I'm a big believer in what it's trying to do, but I'm also a big believer in markets. What you really need is a second source for something like a Facebook. If you really want people to be able to lose trust in something, they need to switch to something else. We don't have any other competitors to Facebook. We don't really have another competitor to Google. So this is the real big problem, is we don't have a functioning market in these kinds of things, where we don't have multiple providers, so people can actually switch when they lose trust.
Have we all been mugs in this? Because I was looking back through some old notes which said data at the top of the page. It's from several months ago, and we've talked about this subject quite a lot. And I've made a note saying, it's free, we take advantage, why are we surprised when they do the same? Why do we need protecting from ourselves, effectively?
Because we're not experts, because as we've seen from Cambridge Analytica, I mean, yes, the framework's been tightened up, but there are big companies will abuse their power, and we need an ethical framework, a legal framework in which to work.
I think there's also examples, and in some cases, who cares that they know how old I am and what gender I am, and so push an advert my way. But in some instances, if it's my banking details or key personal information that could unlock my insurance policies or something which could be really critical to me as a person, that's something we should be taking very seriously. So it's all kind of lumped in together, and people think, well, whatever.
Is it really all lumped in together?
I think when we think about
we headline Facebook, we headline Google, but in fact it's about perhaps our financial security, our physical security.
I mean, everything's online. We put everything into the digital space now, and that comes from, my mother's maiden name all the way down to my shoe size. So some stuff, if it gets passed on, I as a consumer maybe don't care that much, but some stuff could make a real tangible impact to whether it's financials or my personal life. So that stuff under this legislation, which should be handled much more securely and safely, and that can only be a good thing.
Let me ask you one other question about this one. I mean, Britain's going to leave the European Union, more than likely. We're still covered by this.
Yes.
Yeah, we have just passed the Data Protection Act of 2018, which drinks in the GDPR. It also drinks in the Criminal Justice Directive, which we have to incorporate into UK law. And it also, interestingly, raises the bar in certain areas where the GDPR didn't criminalise certain activities, like tampering with someone's personal data before a subject access request. We had no lawful basis for doing that. That's actually a criminal offence.
Just a quick one on this one. We've talked about the fines perhaps either not happening, being meaningless, or whatever. You say criminal side of this. Could people go to jail?
Under GDPR, no, but I mean the potential fines, as we've talked about, are big. I don't think we're going to see particularly enormous fines in the UK, but there are penalties.
Well, under the Data Protection Act, there are criminal sanctions. And remember, accountability is not just at the board level, it goes all the way through the organisation. So it may not just be the boss that could end up being in court.
Just a quick one, if we may round up. I don't know how much time we've got exactly, but when this is all settled down and I'm no longer getting these emails asking me what I want to do and I don't really understand them, how am I going to notice a difference in my life?
I don't know if you're going to really see that much of a difference.
I think, you'll probably see slightly less email traffic. You'll probably still get 60% of it, of people that either think they can carry on or are going to carry on regardless.
Yeah.
And actually, one thing you might find is you don't hear from some organisations that you actually did quite enjoy hearing from.
But if I want to hear from them again, I can just...
Yeah, if you're proactive about it. I think that's the thing. People who are proactive about it and educate themselves about their rights and what they can do. People, for example, that may have historic criminal convictions or a university photo on the internet that they want to get rid of. Things like the right to be forgotten, in some cases, might apply to them. So people who actually have a tangible need to engage with it might see some difference.
But of course, you have to wonder, I mean, with all the new subscribers to whatever it happens to be, I can understand why it's going to make a massive difference. But they already know, if they want to know about me, what school I went to. That's already there, isn't it? I've lost that right.
You have. The genie is out of the bottle on a lot of this stuff. The difference is you will have more rights to take back control of that, to ask a company that's holding that data about you under circumstances to erase it, to take it off the internet, to take it out of their databases. So it's giving you more control.
I suspect that we're going to see this as a starter and that things are going to change. And if it looks like it's successful, then we may see an evolution, as you suggested.
I would hope. Okay. I don't know if legislators think that way.
Okay. Listen, thank you. You've helped clear up a few of my misconceptions. Let's hope that it's done the same for anybody else who happens to be watching this. Europe-wide this, and even if the UK leaves the European Union, it is still going to stay in force here. Thank you very much to my contributors, to my guests today. It's been fascinating. I'm sorry if I came across as a bit of a thicko, but when it comes to this sort of thing, who isn't? I'm David Foster. You've been watching Roundtable. Thank you for watching. Hope to have your company next time. Bye-bye.